Hello, my true crime lovelies. How are you? Good evening. It is the evening of August the 13th. It's Tuesday. Sarah has court in the morning, and WFT has filed an opposition to her motion to have her discovery um, hearing closed, right? So, and I like to think of WF TV as WTF because that is the channel in Florida that brings a lot of first interviews. Like if you're following the Maddie Soto case, they got the interviews with her mom and the mom's boyfriend like day of when everything was going on, or maybe the next day. Anyway, so they filed an opposition, and so I wanted to get into that with you. And then also JAC filed something, and I want to read you the cover letter for what they put. But yeah, let's get into it. I'm a little hoarse, but I'm fine. I think it's like seasonal allergies. So I have a little post-nasal drip. Okay, let's bring this to the screen. All right. Here we go. So, motion to intervene for the limited purpose of opposing closure. So, they stand in opposition to her request for closure. So, WFTV moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings. In support thereof, WFTV states as follows. Number one, they have covered the murder of George Torres, the arrest, investigation, and prosecution of defendant Sarah Boone. Reporters from WFTV attend court proceedings and rely upon state, county, and local public records, as well as judicial records, as part of their news gathering process. And they have been on it. Yeah, okay. Let me make myself small because I'm not going to remember to lean over here while I'm reading on the other page. They've given, they had the video of poor George in that suitcase. This court has set a physical viewing of the evidence for September 3rd and is set to consider the media's attendance at the viewing during a hearing on August 14th, which is tomorrow. Any closure of the physical viewing directly affects the media's and public's right to monitor this important criminal proceeding. As such, WFTV has standing to intervene and oppose any requested closure. See Miami Herald publication, Company versus Lewis, which that is the one that Judge Rainick referenced, and he was going to give Sarah a copy and the state a copy. They didn't really need a copy, but I just think in the interest of fairness, he sent out copies for both of that. So, and I think the media, and I'm gonna do a full disclaimer. I work in the media for a media company as part of my regular day job, but I think the media has a vested interest in not having these things closed. Right now, the judge can restrict what is shown, just like they don't. We don't see the jurors, as they say in the South, my Southern lawyers. They don't show their faces on TV, right? So he could decide what and what not to show. Although I did hear, I don't remember if it was Wooten, because I don't think Kranick said it, but not to like zoom in on Sarah's face. But they have been zooming in. So I could be mishearing that. Like maybe the person who was saying it said the judges in Florida in general said it and didn't specifically say Sarah, so don't come for me if I got that wrong. But if you know what exactly happened, let me know, and then we'll all know. What did Sarah say? You tell me, and we'll both know. So you tell me if you know. Okay, so but they have a vested interest in not having these things closed, and Sarah is always going on about her freedom of speech. The media, I think, definitely has the right to fight for their freedom of speech. So they would like to be heard in this matter and asserts that any requested closure should be denied. So they're being clear that's their position, like just it should be denied. Florida has traditionally served as a model for open government and courts. It is well settled in the state that criminal court proceedings are presumptively open to the public. Oh wait, did I share the screen again? I did not. I'm glad I checked. Good Lord. Here we go. Where did I? The Florida Supreme Court has stated that a trial is a public event. What transpires in the courtroom is public property. Lewis, quoting Craig v. Harney. If you guys want to look all these up, you have at it. But I'm wondering because this says Lewis 426S. Yeah, it's the same one. So Miami Herald v. Lewis. It looks like that's the same one because it's 426 SOSD at 7. And this is SO 2D 1 and 7. It looks like a 1982 case, but Lewis was quoting this other um, Craig v. Harney, that other case. Whatever it is, when the Supreme Court put this together, they cited Lewis, or they were actually coming to a decision on Lewis, and they cited Craig v. Harney. Anyway, therefore, when considering a request to close court proceedings, this court should begin its consideration with the assumption that a pretrial hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. In order to justify closure, the moving party must meet an exacting standard and show. So in this case, our moving party is Sarah because she's the one who filed the motion for closure. She wants to be alone to take pictures, which I don't know why she would take pictures. I'm assuming it would be the private investigator who would be in there taking photographs, but are they going to let her have those photographs in jail? I don't know if there's like an exception for the pro se. I mean, I probably could look it up, but I'm just, you and me are talking right now. Like they can have photographs because I know people in prison don't just get, unadulterated access to any photo that they want. And I don't know. I just keep thinking of the autopsy photos, and we were in the comments earlier. I was in somebody's comments, and they were. I was like, "Do you think she's seen it?" And they're like, "Yeah, it will be in the discovery." But I'm like, "Do you think she's seen it? Seen it? Not if she has it, and it could be in one of those files that she couldn't open up, but it also could be something she's not ready to see. I mainly because she would have to open it up in the dorm, right? So I just wonder, maybe that's also a reason why she wants her office slash classroom, because she is in that open dorm. It's not like she has a private cell or a single bunkmate. What did she say? 53, 63 bunkmates. So, but I wonder now too, do you guys think she's like the OG? You know what I mean? Because she's been in there for something years and it's jail, it's not prison. So most people, even if they get sentenced to jail, it depends on the state, but I feel like it's roughly a year or 2 years. Just because I watch a lot of court shows and I feel like they'll either send you like there's a cutoff. I believe it's a cutoff because of time. It also could be because of the type of offense. But like after, you can't do a 10-year sentence in the jail. You'd have to go to prison type of thing. Oh my God, I said what Paul says type thing. From reporting live from my sofa. I love him. Okay, so focus. Closure is necessary. So this is what Sarah is gonna have to argue. Because she's the moving party. Because I'm guessing they're gonna have to have oral arguments tomorrow, right? They're not gonna just sit there and have they're gonna have oral arguments. So closure or testimony. But either way, for Sarah, that's gonna be an oral argument because if she's testifying, she's not questioning herself. Let's hope. Okay, did I share again? I did not. Oh my goodness. Okay. I'm gonna get the hang of it, I promise. Yeah. Okay. Closure is necessary to prevent a serious and imminent threat to the administration of justice. So I can't see how them recording it is a serious and imminent threat to the administration of justice. B, no alternative other than a change of venue would protect the defendant's right to a fair trial. I don't see how that's going to make it, how them coming in is going to impact her right to a fair trial. Um, closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. So I think in that sense, there is a way, like I said, if the judge limits to what they can see. So basically it's saying the only well, as I'm interpreting it, the closure, it would be limited closure without being broader than necessary to accomplish this purpose, right? So closure would be effective in protecting the rights of the accused. So what is it that can be seen without impacting her rights? And so because it's discovery, some of it can come into trial, but as you know, us trial watchers know, not everything comes in. But there's also, like, not everybody is watching, and I've done jury duty. I take it pretty seriously, when they ask me the voir dire. So if they're like, "Have you seen this? Would this impact you?" Hopefully, everybody would be honest. I mean, we have no reason to believe that they wouldn't be. Of course, Sarah, who's suspicious of everyone, does, but, people who don't think the world revolves around them. So this test also applies to requested closure of discovery materials, which are public records. So here they're specifically citing that it's discovery materials in case Sarah wants to argue that. I don't think she's going to be sophisticated enough to really, excuse me. Sorry guys. I don't think she's going to be sophisticated enough to really argue like point for point, but she might, because Koenig did send her the Miami v. Lewis thing. So Miami Herald, was it? What was it? Miami who? Yeah, Miami Herald v. Lewis. So she may. I mean, she's an arguer. Like this woman argues in her sleep. This woman argues which nostril she's gonna snore out of. Right nostril's arguing with the left nostril. So closure is not necessary to prevent a serious and imminent threat to the administration of justice. Importantly, the fact that the proceedings will involve viewing evidence does not alter this court's Lewis analysis. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. So if Sarah is sophisticated enough to say, look, this is discovery, it may not be admissible as evidence, right? And because she could request, um, um, is it a motion to quash? I don't know. That might not be for that, but she can definitely file a motion to suppress, right? Like we just saw in the Donna Adelson case, Florida v. Donna Adelson, where she's asking for all the stuff about Vietnam to be suppressed. So she could ask for it to be suppressed. Like if I were her, I would be trying to get that video suppressed. I don't think it'll happen, but I mean, I would put it in there. Like the more stuff she can kind of throw at the wall, the more stuff she can argue on appeal, each denial, right? Like have a higher court review Koenig's decisions. So the admissibility part is not it, or they may not be able to lay the foundation. There's a lot of things that may not be admissible. I mean, I think all of us armchair detectives will look at stuff and be like, the stuff we can see versus what the jury can see. There's often a gap. And so, because I think, what is it, Emily D. Baker, she'll always be like, let's think of it from the juror's point of view of like, what are they seeing, not knowing what we know. Or maybe, it might be the lawyer, where he goes in with the open, listen, somebody on the internet. Okay, but suppressing a defendant's statement that included potentially damaging admissions, but refusing to seal the statement, where pretrial publicity includes publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. So that was State v. Cosma, another Florida case. And any attendant publicity is not synonymous with prejudice, right? So just because they've seen it doesn't mean they're going to hold it against her. As the Supreme Court explained, prominence does not necessarily produce prejudice, and juror impartiality it doesn't produce prejudice and juror impartiality. So it doesn't mean just because they see it they're gonna be impartial. They may see it and still come in with fresh eyes and in the context of the trial, be impartial about it, right? They will use their common sense. We have reiterate does not require ignorance. So you don't, yeah, you don't have to be in this instance, not ignorance as in how we normally, but ignorance of does not require you to not know, right? Yeah. So they can still be impartial. It doesn't preclude it. Just because they've seen it, if they see it too. That's the thing too, right? That's a hypothetical. We don't know if they'll see it or not. So it's, I don't know. It's kind of hard to argue for that. And especially like her argument so far. And she's going to be very emotional, right? Because in the other one, in that clip, she was just like, I want to say, I think it's very unfair. That is my business. Like, honey, we're going to see most of this eventually anyway. But it's going to be, that part's going to be hard for her because she's, in my opinion, going to be like defensive, not Sarah Boone, and emotional. But again, because she has this perception of, the world revolving around her and never being wrong. And so people's just seeing all of her dirty laundry, that's going to be hard for her ego. And that's going to drive the emotional stakes up even higher for her. Every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it and who has not some impression or some opinion in respect to its merits. A presumption of prejudice, our decisions indicate, attends only the extreme case, right? So it's going to be the edge cases, few and far between, of people who are going to see that stuff and come to a conclusion about it. And I was watching yesterday the knocking neighbor shooting, and when they were doing the voir dire for the jury, and they were asking, like, have you seen, a lot of people had seen it or had heard of it, but not in depth. They're not on YouTube like we are, scouring for information, court files, putting in FOIAs and all that. So if they watch the news, it may have made in their local area, the 6 o'clock news. And so in that sense, they've heard of it, but again, they don't know like all the sordid details of it. So pretrial, let's see, Skilling versus US. See also Nebraska Press Association v. Stewart. Pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. So even there, they're going, above. I think though, honestly, pretrial publicity in this day and age, because they're quoting, what is that, a 1976 case? It's very different with social media, right? You have at least on YouTube right now, maybe 20 channels talking about Sarah Boone. So if the juror watches YouTube and watches true crime, but I think they probably have to disclose that. And then the lawyers have to decide, just like you hear how lawyers don't want other lawyers on their jury. Maybe they don't want, true crime addicts on their jury. I would have to be on. I wouldn't be able to be impartial. Like if I was sat for this jury, obviously I'm in New York, so that's not going to happen. But I would not be able to be impartial because I'm just too involved in it. I don't see in my mind how she's not guilty, and so they would be starting, I don't have a presumption of innocence for her, and I would not be able to pretend to. So they'll be behind the 8 ball, and they have the burden. Basically, I would be taking the burden away from them. I would be telling Sarah, "You need to prove to me that you're innocent," which that's not fair to her. So she definitely deserves a jury that is going to presume her innocent and make the state prove their case. Noting even massive pre-trial publicity about a case is not enough to show a serious and imminent threat to the administration of justice or to the denial of fair trial rights. Yeah, because can you imagine if we lowered the bar on that, there would be so many cases that wouldn't be able to move forward or wouldn't be able to seat a jury because people had seen it or heard it on the news. Second, and also it can help the community because things can be going on and you see a case, like in the instance of serial killers, and then you start putting stuff together. Oh, this, if in the unfortunate event that one of your family members was killed, or robbers, any criminals or any people allegedly who are criminals or accused of criminality, you could see something on the news and be like, "Oh, that happened in this neighborhood and that is similar to this other thing that happened to us," right? And so if we're suppressing all of that, or if there's something in discovery that's like an heirloom, a family heirloom that was stolen, and you see it because it was found in the home of the defendant, and you see it and now you know that this person has been in your home. So there is a societal benefit, other than just like the public stoning that Sarah thinks it is. Right. Remember she said about casting stones. Okay, so let's see. Number 10, finally, closure would be ineffective and broader than necessary to protect the defendant's fair trial rights. When prejudicial information already has been made public, i.e., Sarah, I can't breathe, there would be little justification for closing a pretrial hearing in order to prevent only the disclosure of details which had already been publicized, right? So I think most of it has been publicized. I would say the only thing, well, I can't say the only thing, but in my mind, the most prominent thing that we haven't seen are the autopsy report and photos. So, in that sense, when they're saying about the broadness of it, so they could limit what could be seen. The judge could limit what could be seen, right, and not make it overly broad. So, yeah, that's. I think he's going to grant it, and I think he is going to. Well, not that he made up his mind. I like this judge. He's thorough. Just like he said, he took a lot of time in putting together that 16-page order and getting, like, he's working his hardest to make it, appeal proof. So I feel like looking at everything and weighing everything, he is definitely the judge that's going to do that. I mean, I'm sure most judges are, but sometimes, you get those ones where you're like, you question their call. I just don't feel like there's gonna be a basis, and that would be something that, well, would the state appeal it if they didn't win? Um, yeah, so in that case, I would err a little more on the state side then, right? Because they don't have the right of appeal if push comes to shove. If that ends up being a thing, um, Sarah could appeal it, and then I don't think they would overturn for that, but she might get a new trial. So I think that's why he's being very thorough in doing the research. There is no doubt that in this particular case, the information has already been well publicized. That's why you and I are here right now. Accordingly, this court finds that defendant cannot meet her burden under Lewis. Oh, they are quoting this from, so not about the Boone case, but they're quoting it from State v. Bush. And then State v. Smith. As to the third prong of the Lewis test, the defendant failed to show that granting his motion would be effective in protecting against the perceived harm. Right. Yeah. Since much of the information has already been made public, there's little justification for granting the motion. Rather than a hindrance to the administration of justice and Sixth Amendment rights, heightened public attention only increases the need for the appearance of fairness, so essential to public confidence in the system. Press Intercompany v. Superior Court of California. Oh, sorry. Publicity is vital to an open and accountable judicial system. As former Supreme Court Chief Justice Berger explained, without publicity, all other checks are insufficient. In comparison of publicity, all other checks are a small account. Well, there you go. Closure of social proceedings should be ordered only when there is a serious and imminent threat to a defendant's right to receive a fair trial. And even then, alternatives must be considered and restrictions must be narrow. In this case, there is no strict and inescapable necessity for closure, and this court should deny any such request. I mean, yeah, that sums it up. There's nothing in there like to broadly close everything. There's nothing in there. um well, there's a lot in there that's already been seen, and so if it's just specifically not showing new things or not letting that out, then he could restrict it, but to close the whole thing would be overly broad, right? um because then they're saying alternatives must be considered and restrictions must be narrow. So like if you want to restrict it, fine, but don't close it entirely, which I think is fair because I want to know for sure. So, wherefore, WFTV requests that this court allow it to intervene in this matter for the purpose of opposing closure and deny any requested closure of the September 3rd, 2024 proceeding. So, and then that's Rachel E. Fugate, attorneys for WFTV. And then there's a service. So, they just filed this yesterday. Right? E-filed it. I don't know if Sarah's gonna see this before she walks in, before they kick her bunk at 3 a.m. tomorrow morning. Yeah, they filed that. I'm sorry, Monday. Today is Tuesday the 13th. So they filed it on Monday the 12th in the afternoon at 3:27. I wonder if they did that strategically too, right? Because if they mailed it to her like at that time, around that time, the mail could have gone out for the day. I don't know if they have a requirement to walk it into the post office and do like certified, but that's end of day. So would she have received it today on Tuesday? She damn sure going to get it tomorrow before court because they wake her up at 3. So I wonder if that was a strategic play on their behalf because she's going to be knocked back on her heels. I mean, she has to prove it. She has to argue it either way. But to have someone openly in court that is not the judge and not the state, like, arguing against her, I think that's gonna be rough on her. But you know what? This is what she gets for going through 8 attorneys. Yeah, I think it's super interesting, and I also, because 'cause I've seen a lot of videos of people talking about the plea deal. I don't really think there is a plea deal. I think they want to be in a situation under the guise of a plea deal so that it can be closed, right? To allow her to do that because what happens in a plea deal doesn't go on the record, because it can't be held against them. So, at least that's how I interpret it, can't be held against them. So I don't think that it goes out in open court. Although people keep saying she got a 10-year plea deal, and I realized I was just repeating what I heard. I didn't actually like see any documentation of that. So perhaps some of it is open because how where would people get the 10-year number from, right? Or maybe you can reveal the terms of it after it's been declined. I don't know. We're gonna learn together, child. But yeah, I feel like he's not going to close it completely, and she's gonna have a conniption. And it sounds like she wants her investigator to be there. I'm gonna show you this other thing, then we're gonna wrap it up. We're at 28 minutes. I want to just show you what the JAC said. Yeah, it just it's a lot, y'all. It's a lot. Okay, share. Let me make it big. This was 8/9 at the end of the day. So the day of the what was that, Wednesday's hearing? Although I feel like they said they would give it to her at the Monday hearing, but whatever, they got it to her. Let me see. Make myself tiny over here so you guys can see it fully. It says 151 pages, honey. We're gonna read page 1 or maybe page 2, but this is basically the document that she asked for. So here is the certificate of service. I hereby certify that a true and correct copy of the foregoing has been sent. And so that was on the 9th by Anita, and they e-filed it on the 9th as well. So hopefully this is the right address, Legal Mail 9101 from the Justice Administrative Commission. So they do all the funding for indigent oh my god, what are they called? Indigent defendants. So the yeah, out of the public defender's office, even though she's now disqualified from having one. Ms. Boone, thank you for contacting the Justice Administrative Commission. I feel like that should be, I don't know, like the headquarters for Superman and those guys, right? Like the Justice League. Anyway, regard regarding your public records request, in response to the court's request received by JAC on August 5th, 2024, enclosed, please find a copy of the JAC policies and procedures for pro se individuals, as well as JAC invoices and other related pro se forms, which may assist you with your request. The due process rate chart and a complete list of service providers that have executed contracts for payment by the JAC in the Ninth Circuit Judicial Circuit are also provided. So that is important if they're already executed, because if they're not, that takes a much longer time, because you would have to get a contract executed, like an MSA, a master service agreement, which if you've ever negotiated one of those or been involved, it takes a long time. It can take a long time. So that hopefully she understands that, and we'll just pick from the providers that already have a contract. Please be advised that the JAC pays for only those due process costs which have been authorized by an appropriate court order. You will need to file a motion with the court requesting the court's approval for payment of any due process services. JAC will need to receive a copy of your motion at least 10 days prior to a court hearing on the motion. Yeah, I wouldn't be filing any of those, honey. You don't have 10 days to spare. What is it, like just 50 something days now? If your request is granted by the court, JAC will need a copy of the court's order in addition to a completed JAC invoice to process the payment. JAC invoice must be signed by you and the due process vendor. So that's going to be like the invoice that Billy Lane gave to her in the last, I think it was last week, whether that was Monday or Wednesday. It must be signed after the work has been completed. So random tangent. The executed contracts, have an executed contract and having those authorized by a court order. So that was when I really started following the court proceedings of it. Like I was aware of the case, but like she was going through lawyers, but I hadn't really tracked it. So that was Bankowitz's second filing for a motion to withdraw as counsel. They also had the JAC there. They were up on the big screen, and that was still with the prior judge, Wooten. And Bankowitz was arguing that he couldn't find anybody. He couldn't find anybody for the price that was offered under the JAC rules. And so he wanted more money. And also people, he was saying they were concerned about the publicity of the trial. Basically, like they don't want their name muddied, defending this woman who is on video recorded by herself taunting the man she murdered. And so, because I remember Sarah seemed confused, like after the withdrawal was granted, because Judge Wooten at that point specifically asked her, like, do you want him removed? And she was like, yes. And then she seemed surprised because that then made the JAC bit moot, right? Because she was going to get Hobson, and Hobson may have had a different defense strategy. So, but she looked confused, like, why aren't we going to ask the JAC for the money? Again, I don't know if she's playing dumb or what's going on, but she has to, at least now, right, realize that whenever you get a new attorney, it delays it and you keep going through attorneys, because now she's hinting in her passive aggressive way that she has a very limited time. Well, yeah, just like all the other attorneys, you have to give them time to get up to speed. And when she's in there like, oh, well, I haven't, wait, let me get back to you guys. I haven't had time to review all these things fully, and I didn't want to waste my time, and I couldn't get these open. Now you know how your attorneys feel. Like they have to go through all of it. And as I understand it, I think it was either Padilla or Bankowitz who sorted the files out because he was like, it's a mishmash of whatever in the banker's boxes. And so he had to sort them out. For her, I'm sure whoever did it, whether that was Billy Lane or someone else, they're in some kind of order because she mentioned things in folders, right? They were in folders and then she clicked in that folder and couldn't get everything else open. So the folders have to have names. Somebody has organized something for her, which is more than what the earlier attorneys had. I feel like that first one that she had that was a public defender probably didn't even look at it because it was so quick. Because then Brian hired the attorney Padilla for her. So that very first one she fired, even though she's like, I haven't fired any of them because she hired counsel. Like she paid for someone to do it. So then we don't have to say fired, released, whatever. His services were no longer required due to an action that she took. I don't know if that first one even looked at anything, but Padilla certainly did, and for 2 years. So I that's what I'm like, I don't know if all the bells are going off up there, if the elevator's going to the top, if the Happy Meal has all the french fries, because like, for us, it's obvious. Of course, it takes more time every time you get a new lawyer. Of course, that's delaying it back. Of course, you've waived your right to speedy counsel, which would have happened with Padilla. You waived your right to speedy counsel, but she's like, "Oh, I want to see where I signed that," and then we find out she's missing court dates. I tried to go back through, and maybe when I have more time, like over the weekend. Luckily, Sugar Bear is asleep tonight, but I don't want to stay up all night. We'll see. But, like, what were the dates? Because maybe they were her family court. I tried to go through the family court. I did look at that, but now all of those documents are not sealed, but basically, like, you have to have an account and blah, blah. Like, I printed it out. They need a what do you call it? They need to be notarized, and then I still might not get access, but we'll see. I know before they were. I wish I would have downloaded the files, but she may have missed court dates for her other case where she's trying to get her alimony reinstated because Brian just took it upon himself to stop paying it, and she's like, "Oh, my account is closed, and I had it for 30 years." Girl, you don't need a bank account where you're going. What you need is whatever those little prison accounts are, and that's it. So, yeah. All right. Oh, wait, I was gonna show you one more thing. Hang on, and then we'll get out of here. There we go. Okay. Is this Oh, no, that's the wrong one. And is it back on the screen? So many things to remember. So, the 10 days, the invoice. Okay, so yeah, she'll be signing that invoice that, Mr. Lane talked about. So this is the pro se information packet that I can't remember his name, the lawyer though that was on there from JAC. So in here is the authority, requirements, establishing indigency, which she's already done, allowable costs, motions in order for due process services, court reporter services. See, now normally this would be like, you would think this is the table of contents and like on page 3 you would find these. No. Oh wait, that's there. But the other one had, let me see. I'll make it easy for myself. Private service of process is 7. So I would think that would be on page 7. And we go to 4, 5, 6. Sorry if it's going too fast. Close your eyes. Okay. And then here's 7. Oh, no. Now listen. How is that possible? I swear I looked at this earlier. So how do we get to, so basically this is, I'm tired. From 9 on are the vendors? I guess that's fair. Let's see. Let's go to 9 and see if that is the vendor. Maybe I shouldn't have started from the back end. 9. Yeah, that looks right. So from 9. Oh, no, this is 9 of 9. And then are the attachments. So where's the vendor page? Due process vendor list. They maintain a list of due process vendors with with current JAC contracts. The information on the list is from the vendors and has not been approved or checked by JAC. It is a responsibility. What? They have contracts where they haven't been approved or checked? That doesn't. What are you doing with the taxpayers' dollars? Come on. It is the responsibility of the defendant using the services of a listed vendor to check their professional qualifications. The listing of a vendor on JAC's list does not mean that JAC recommends or approves the hiring of the vendor. In addition, even if a vendor is listed, JAC may still object to the trial court's authorization of payment of the vendor, including any objection to rates higher than the rates established by law. It is the defendant's responsibility to make diligent efforts to obtain services within the rates. So that's going to be Mr. Lane doing that. So see, that was page 9 of 9. Um, and then the rest of these are not listed. Page numbers, I mean. Motion to incur costs. So there's a bunch of motions. Like, let's, huh. Yeah, I was trying to go through here earlier and find like a sample of each. And that's why I thought like these numbers don't correlate, but it's a 9-page document. And then, but they don't list that clearly. Like, why doesn't it say what page 10 through 151 is? Anyway, so they sent that over to her. Luckily, she does not have a capital death case. So crazy to me. Yeah. I don't know, guys. There's a lot going on. So we'll see tomorrow. I am not going to be able to do a live reaction. So I'll do one in the evening. I have physical therapy tomorrow and I have like, I'm slammed. You guys don't care. I'll do one in the evening. I'll do a reaction and then maybe a premiere. We'll see. It's gonna be all the way live tomorrow, though. I feel like we're moving at a good pace now, and I like that. And then that gives her something to be focused on. She should be focused on her case and not writing nasty letters. I'm sure she's gonna mention she hasn't heard from the captain. I honestly just hope the captain ignores her. Like, does she have to answer her? Like, she wants a classroom, a telephone, a copier, internet access, a copier and a printer, which they can be combos. So, but you know what I mean. Like, I hope she just doesn't answer her. But I feel like she'll keep going on and on. I don't know. Maybe Miss Captain D Giovanni will be in court tomorrow because it wasn't filed as a motion, and we learned from the Adelson case, like the judge can't just demand that the jail do something. Maybe they'll come in there with the captain and everybody else like they did with Donna or Miss Adelson, right? Like the one came in there basically and said the attorney was lying. Like she hasn't reached out to us. She hasn't reached out to blah blah blah. Although I didn't look at the paperwork. I don't know if the judge summons them to that. Maybe, yeah, maybe he did because why else? How would they even know that was happening that day? Yeah, interesting. So we'll see. We'll see tomorrow. What do you guys think? Is she going to get emotional and crazy? And I'm also trying to figure out who will be her witnesses. I think she's going to call Brian, but Brian is going to be a witness for the state. So that gets a little like flippy floppy. I feel like that'll be more like a Wendy Adelson. No, because I feel like he really will be for the state. I was going to say it'll be like that testimony where it's like she's a little sweeter to him, but she's gonna have to defend herself against what he's saying. Like if he's saying she's drunk most days and doesn't pick up the child and all that, like she ain't gonna like that at all. And then she'll be, instead of addressing that, she'll be attacking him, like, oh, what about the time you did this? So like she's gotta get her mind right. Well, tomorrow she will be shackled at the ankles, hands free, shackled at the ankles and at the defense table. Hopefully the cameras move around to where she was sitting so we can see like both her and the prosecution at the same time. And I wonder if Georgia's family will be there. They probably are not going to come into the trial. Can you imagine waiting this long for justice? It is so crazy. Although I will say, like, my brother was murdered at the end of 2001 and it did not go to trial till 2006. So that was a long way, but it was going to be a death penalty, or it was a death penalty case. I think it just takes longer. Like the guy kept dragging it out. Even though he was in custody. Anyway, it is definitely hard when you're waiting for justice or waiting for something to happen and not feeling like that person is just not being held accountable, right? Because they have the presumption of innocence. So hopefully I'm sure the DA is calling them and letting them know like what's going on. I was the point person for our family. So yeah. All right. I'm just in my head now. I'll talk to you guys later. Thanks for hanging out with me. Please like if you like it and, drop me a comment. I love talking to you guys. Like, I feel like we need to be on a Zoom call every day together. So let me know your thoughts down in the comments below. Toodles. I'll talk to you guys later. Bye.